Hello, I'm Richard Seymour, Rick for short. I'm a mediator, arbitrator, and lawyer. My ADR website is www.seymouradr.com. It contains probably more information than you'll ever want to know about me, and it links to my litigation website, www.rickseymourlaw.com, which contains copies of a lot of my papers and presentations to state and local bars, the American Bar Association, federal training conferences for judges, and that sort of thing. I made this short video to address three important questions. First, can video mediations be as effective as in-person mediations? Second, is there a good reason to do a video mediation now as opposed to waiting until things get back to normal to do the kind of in-person mediations we're all used to? Third, are there any silver linings in this cloud of the present circumstances? The answer to the first question is clear. The jury is in. Video mediations are an effective means of resolving disputes. There are a lot of them taking place right now. Virtually every mediation services provider is offering mediation by video, and they're reaching settlements. And the parties to those settlements are either equally satisfied or equally dissatisfied with the outcome, the same as with in-person mediations that we're used to. How is this possible? Well, it seems to me that to a good advocate, the platform does not matter, the skills of the advocate matter. For example, when taking a deposition, it is important to be able to cross-examine effectively, sense the way that the witness is going, frame the question, use the right tone of voice in order to get the desired response from the individual. That can all be done in person. It can be done on video, and I've done it hundreds of times in telephone depositions. I've had no trouble in determining credibility, in deciding when to examine, cross-examine, to use a difference of change of tone, change of emphasis, and so on, in order to get the result that I suspect is out there to someone who asked the question the right way. And my opposing counsel have also had no difficulty in making those kinds of determinations. Now, telephone depositions are a far cry from in-person depositions. But here's the point. To a good advocate, it is the skill that matters and not the platform that matters. Now, there's a statement that's gone all over the legal internet that you have to be in the room in order to smell the fear. Well, that's kind of amusing to me because it just doesn't make any sense in a mediation where people are in separate caucus rooms and that's where the actual decisions are made. They're not in the room with the other side. They cannot go sniffing around to try to smell fear. But I understand how some lawyers will either doubt their own skills and think that they're not going to be effective unless they can be physically present with the mediator. And I can also understand how lawyers want to spin their skills in order to impress their clients. Now, some clients may not have the same kind of elementary school playground fixation that this seems based on, but that's just not really a factor in having an effective mediation. My answer to the second question is that for most parties, it is better to resolve a dispute now by video mediation rather than kick the can down the road for an unknown period to wait for a new normal to arrive when we can have in-person mediations again. The problem is that the new normal may not look anything like the normal that we're used to. For example, the backdrop of mediation before the coronavirus crisis hit is that mediations worked because the alternative was litigation and the certainty of an upcoming trial, motion for summary judgment, or some other major turning point in the litigation that was going to be expensive to engage in and uncertain of result. Right now, that's simply not happening. There are no trials taking place anywhere in the country. We're not sure when the trials are going to resume. Papers are still being filed in federal court. There's an organization that's very, very useful called Lex Machina. Now, that just means the law machine in English. But it's so much more elegant to put it in Latin, don't you think? Anyhow, Rachel Bailey of Lex Machina put a blog entry in on April the 14th showing that comparing March 2019 in federal court to March 2020 in federal court, dismissals of cases on the pleadings were down 37%. Grants of summary judgment were down 29%. And trials had not stopped then, but as of the point the end of March, trials were down 41%. Now, that pressure to settlement is gone. And it's going to be a while before it comes up again. Because what happens when you have cases that are being filed in court and not resolved in court is that you have a huge squeeze in the middle as those cases are working their way through. I put up in the corner a cartoon of a snake that has eaten too much and is going to have to take time to digest. We've all seen pictures like this. And it's an amusing cartoon, but think of the litigants. Think of the squeeze on the parties, because it's going to take a long time to digest that load that is in the court. And in that period of time, parties can go bankrupt. Defendants, companies that are plaintiffs, can go bankrupt because they don't have the resolution of the case that would enable them to attract financing and be able to continue, or the results of the case, the damages that they need in order to be able to become viable again and continue. Individuals may face an enormous personal squeeze. They may face eviction. They may face forfeiture on their mortgages and foreclosure because they don't have the resources that they need to carry on. There's an enormous economic squeeze right now that can serve as the alternative to the litigation squeeze that is a driver of mediations. So that is very different from what we've had before. But right now, if one needs to have a case moved, and if the lawyers on the two sides are not able to do it together, there are only two ways to go, and that is video mediation or video arbitrations. Those are the only choices. It doesn't matter if we don't like the choices. Those are the only choices if our clients need to have the case moved. The third and final question is whether there are any silver linings in these clouds. My answer is yes. It breaks down into travel, choice, and discount. As to travel, a lot of mediations do not require that anyone travel. At least a lot of mine have not. But a fair number of mine have required that at least someone travel. I mediated a class on collective action in which more than 70 people had to travel. That was expensive. I mediated an individual case in which more than 10 people had to travel. That's also expensive. It's hard to get the settlement authority to attend mediations when there's travel involved because they've got a lot of other responsibilities. Take away that additional time commitment and just strip it down to what's essential for the mediation, and it's going to be a lot easier to get their attendance, which is going to boost the chances of a successful resolution of the case. So that's one factor. Expanding choice is another. Without having to pay anything extra for a mediator from across the country, your choice of mediator is expanded to become nationwide with a video mediation. Third is discount. To give an incentive to people to dip their toes in the water of video mediation, I'm offering a 1/3 discount on video mediations that are booked between now and the end of June, even if the mediation has to take place later. Now, how do you arrange this? That's easy. Go onto my website, and on the first page of the website, there is a form that can be downloaded for video mediation. Just talk to your opponent, get agreement, fill out the form, and send it in. Or you can contact the American Arbitration Association and the American Health Law Association. For both organizations, I'm on the roster of employment mediators and arbitrators, and for the American Arbitration Association, commercial arbitrators as well. Thank you very much for listening.